Good morning, Your Honor. If it may
Morning.
please the court, I'd like to reserve five minutes
minutes,
for rebuttal. My name is Mike Working. I represent Mr. Tyrell Webb. I'm a member of the Memphis and Shelby County Bar. And I was expecting my co-counsel Josie Holland to argue this case today. We were given an extension on our reply brief so she could become a parent. And she has not decided this week not to come back to work yet.
Well, congratulations.
Yes.
Congratulations. Mr. Working, before you start, I mean, this is a sentencing case dealing with the manner of service of the sentence. Does the brief accurately describe the standard of review?
Well, partially. I think that we agreed that it would be a abuse of discretion standard. The brief may miss the fact that there is supposed to be a presumption of reasonableness absent certain showings, which I believe are present here.
It seemed to me, it looked like the brief was citing cases prior to Bice, suggesting that the standard of review was de novo, and also suggesting that maybe there was a presumption of alternative sentencing. And I don't know that that necessarily follows from Bice.
It's my memory of the brief that we argued the issue of denying the ability to cross-examine is de novo.
Okay.
However, the issue of sentencing is abuse of discretion, and I do not remember writing in the brief with a presumption of reasonableness, but I am going to argue that that's the proper standard
That's
today.
okay. We all agree, though, that there is no longer a presumption of alternative sentencing. Do we agree with that?
I can agree that that's not the presumption in this case.
Okay.
I believe that it is the presumption in many other cases, including C, D, and E felonies, but of course, we're here on a B felony.
Okay.
And I would concede that that is not necessarily a presumption that you are automatically a good candidate for alternative sentencing.
Fair enough.
As I prepared my argument over the weekend, it had been some time since I had been here. There were not lights and a clock on the podium. Mia Miles was our clerk, and the Honorable John Everett Williams was sitting here in the center, and I was feeling a bittersweet about returning those changes. But as I prepared my argument in my office, CNN was blaring coverage of the Burning Man Festival, which was oddly comforting, as a man covered probably in mud, but wearing an immaculate white fur coat, who referred to himself as Zandu, gave an interview to a stiff CNN anchor. And as I was preparing my remarks, almost as if it was a blessing from the Black Rock Desert, I came across the Eakes opinion released last week and joined by two members of this panel about what appears from that opinion to be a remarkably similar proceeding. Now, Eakes involved diversion and a different conviction, but it's remarkably similar in that the law, the analysis, and the procedures in announcing and justifying the sentence of the trial court are totally inadequate. In Eakes, frankly, the trial court did a much better job of citing to alternative sentencing factors, citing to the electroplating and Parker factors. And in no way was any of that done in this case. Frankly, the trial court in this case falls far short.
But unlike diversion, just the denial of alternative sentence, whether it's probation or what, I mean, as the courts made it very clear, unlike in diversion where there are the electroplating factors and you've got to go through those, there are no magic words, to quote the Supreme Court and this court, when it comes to sentencing on denial of alternative sentencing. So while I understand what you're saying, the trial court in here doesn't have to say, hey, factor 1 is this, factor 2 is that, factor 3 is this, whereas for a diversion case, they do. They have to say, per electroplating, factor 1, I have to consider this, it weighs this way, factor 2, I have to consider this, it weighs that way. There is a difference.
I agree there is a difference. And to turn back to Judge Greenhold's question, as was stated in that opinion, and citing to King and Caudell, the presumption of reasonableness does not apply when the trial court fails to consider and weigh the applicable common law factors. Now, I agree, and the state's brief is entirely based on the fact that there's no magic words. I agree that the trial court may need not to go through every single factor, but they've got to go through some. They've got to go through some. And in Eakes, the court just says summarily, I've considered the electroplating factors.
But it didn't
We
know
don't even
weighing.
have that.
But it didn't know weighing.
That's correct. The court in this case did not even say that, did not even say I've considered the factors, much less weigh them. The court actually, almost the only thing that's required in the Parker factors, since it's alternative sentencing, not diversion, but they're essentially the same factors, 8 of them. What the court says in this is, almost its entire remarks are, I've considered the psycho eval, which is presumably a reference to the psychosexual evaluation as part of the pre-sentence report. Counsel in Eakes, in the opinion, this court states that the defendant's primary contention was that the trial court failed to properly weigh all required factors and articulate the specific reasons for its determination that the defendant should not be granted an alternative sentence. And further, they contend that the trial court placed undue weight on an irrelevant factor that tainted its decision-making process. The court's, in a light most favorable to the court, considering the court reasonable, the court says, I've considered the psycho evaluation, which is not, proper in any way, proper term. And then it says, you keep violating the sex offender registry, which, in fact, no. Every single, first of all, the whole hearing's off the rails. The entire cross-examination of the appellant, in this case, Mr. Webb, is about his arrest history.
He
not his-
violated the sex offender registry by committing this crime, didn't he?
No doubt.
All right, so
No
I mean,
doubt.
there's at least one violation.
But it's
of
not
sex-
proper for this court to say you've done this many, many, many times.
All right, so at the end of the day, is the record sufficient for us to make a de novo finding rather than remanding it?
I'm not sure I understand.
Well, let's say that the trial court, and I don't know that I agree or don't agree, actually, but let's say that the trial court didn't make the appropriate findings that it should have for denial of alternative sentencing. That places this court then in selecting one of 2 alternatives. 1, we can remand for additional
Yes.
findings, or 2, if the record is otherwise complete, we can conduct a de novo review. Is the record sufficient here for this
No.
court to conduct a de novo review?
No, and we don't argue that in our brief.
Okay, is it though?
Is it?
No.
Okay,
And the
because,
reason that it's not is first of all, there's no credibility findings of any kind because cross-examination wasn't allowed. There's no,
How does, well, I mean, I know that's your second issue, but how does the cross-examination of the victim play into the sentencing of the defendant?
in terms of the alternative sentencing. So if we're looking at confinement then, and the trial court must find maybe perhaps one of at least 3 factors. One, that there's a long history of criminal conduct, that to grant an alternative sentence would unduly depreciate the seriousness of the offense or affect a general deterrent. Or 3, that lesser restrictive measures have been applied unsuccessfully. There is a long history of criminal conduct here, and there is evidence that lesser measures have been tried unsuccessfully. That's the sex offender registry issue. So none of that, going to Judge Dyer's questioning, none of that depends upon the cross-examination of the victim.
I understand that. What the victim did in this case was got up and talked about their joint membership previously in the gang, that she went to the gang, that she asked for a criminal sanction from the gang. She didn't like the ruling of an illegal criminal enterprise court and decided to come forward. There were a lot of questions
Okay,
about what
great.
was happening.
I mean, I get that, but your client pled guilty to rape. So in the brief, I remember you, if I recall correctly, I should say, there's some talk about, well, this goes to, we weren't allowed to challenge the victim's credibility. What does the victim's credibility have to do when your client has accepted responsibility and pled guilty to a crime? She could be the most incredible individual in the world, but your client pled guilty and said those facts are true and I accept responsibility. And so, back to the question that Judge Greenholz was asking, what does her testimony have to do with his criminal history, the fact that measures less restrictive haven't worked? It has nothing to do with it.
As alleged in the brief, the victim, when she got on the stand, went way out of bounds about what had been pled guilty to all sort of 404B information, all sort of things for which he'd never been charged or convicted, all sort of things that were totally outside the scope of the hearings. And when his lawyer at that hearing attempted to question or follow up on that, the judge shut him down and said, you are not allowed to ask any questions in a rape case. It's outrageous that it's even
Okay, well, then
eligible for an alternative sentence.
I'll go back
Rape
to
is
Judge
rape.
Greenholtz's original question then. Assuming, as you just put it, this sentencing hearing was completely off the rails.
Yes.
I go back to Judge, why can't we look at this de novo? I mean, it seems to me, even based on everything you're saying, I've got a guilty plea, I've got a psychosexual evaluation, I've got a pre-sentence report, I've got all these things I need to determine whether or not alternative sentencing is correct. Why do I need to send it back?
Frankly, because this trial court needs to learn how to do sentencing hearings correctly, and
Well,
that's a very important
If
role of
we
this court.
point that out in our opinion and impose a sentence, isn't that just as much, quote, teaching a trial judge as it would be to send it back and make them do it again?
Perhaps. I would say that the best remedy is to have assurance that the trial court knows how to handle sentencing hearings. And that's why that's the remedy we've asked for.
I did not look. Is your client out on bond pending appeal?
No, sir. No, sir. He has been in for some time, but frankly, at the risk of sounding glib, the procedure in the trial court completely lacked any judicial gravitas. The reason that the trial court gave, after citing the psychosexual eval as the psycho eval, was, I'm from these streets, you should make better choices like me. It's important that judicial proceedings have a certain gravitas, especially in a case that's this serious. It's important that this court not just correct Mr. Webb's sentencing hearing that went off the rails, but we put in a procedure so that they don't all end up like that. Your Honor, I do believe that even though the charges are totally different, the defendant is different, that the Eakes opinion has a lot of value here because the real problem is the total lack of explanation of the trial court in ordering a sentence in the Department of Corrections. It's a total paucity of the ruling. There's just nothing there. And the state cites that there's no magic words and then says what the court meant was this. In other words, what the court was saying was this. But the court needs to say it. The sentencing court, the trial court, needs to say it. And for that-
Outside of the victim's cross-examination, is there other proof that Mr. Webb was not allowed to present?
There were no other witnesses.
Okay. Maybe going back to the question one more time, if you'll help me with it, please. Why is the record then insufficient for a de novo review?
Well,
If the defendant would have offered no additional evidence, and the real complaint is just that the trial court didn't make findings and, to use your words, were lack judicial gravitas. Why is the record insufficient for us to conduct a de novo review?
Because we have no idea what the trial court's reasoning or thinking was.
Well, I mean, in a de novo review, that's not as high a priority.
Fair. My time is up. I'll pass to the state.
All right, thank you, Mr. Ward. All right. General?
Good morning, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. I'd briefly like to comment on the defendant's complaints about the judge's conduct and how this sentencing hearing has gone off the rails. To be clear, there is no complaint about judicial misconduct or that the trial court erred in any way other than the two specific issues raised in the brief.
Well, General Coleman, let me ask you this, though. At what stage, at what point did the trial court do, so you're correct. Many cases out there, there are no magic words. I've not looked at all of them, but I'm willing to bet that in 99% of those cases where we've said, oh, there are no magic words, but blah, 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 at some point in that sentencing hearing, the trial judge at least says, I'm required by statute to, and then reads a laundry list of things that they are to consider. Maybe not reads all of them, maybe doesn't say them exactly like the statute says, but they at least acknowledge there's some stuff out there they have to consider. Here, again, we haven't read the record, but here it appears that the only thing the trial judge considered, or said she was considering, was the psychosexual evaluation. How, I mean, that's even a stretch on the no magic words argument.
Well, I think the no magic words and the considerations are two separate issues where the court sort of does the litany of these are the things.
Well, but I think, and I'm sorry, but I think what gets you to the no magic words analysis is the fact that at least at some point in the hearing, the trial court acknowledged I'm supposed to consider these things. And then they may not say them correctly or may not say them fully or may not say that, you know, the fact that this pen is red goes to factor one or whatever. But they talk enough in connection with these things over here that we go, hey, there's no magic words, but we all know what they're saying. And what you try to do in your brief, you know, the trial judge said this is what this means. But again, usually that's because they at least acknowledge what they have to consider.
And again, Your Honor, I think those are two separate things. So the trial courts generally go over this litany of I'm required to consider all of these different things. But I'll point this court to our Supreme Court's decision in State v. Trent when it's talking about these magic words. And it says what we're really looking at to get to an abuse of discretion with presumption of reasonableness standard is that the court, quote, articulate the reasons for the sentence. So what we're really looking for is the court to say, I am imposing this sentence for these reasons.
Okay.
And that's what the trial court judge did here today. The judge said, here's why I am ordering a sentence of confinement. One, you are, quote, a danger to the community. And the state respectfully submits that that's pretty close to commenting directly on, or pretty close to almost saying the magic words of his history of criminal conduct. As Judge Greenholz pointed out, there is a lengthy history of criminal conduct. The judge also talked about deterrence. And again, didn't say the magic words of deterrence, but said rape is happening too much. I've got to do something to protect these victims. Again, that's going towards deterrence, and that a sentence of confinement is likely to reduce other people from committing rape.
There was no evidence in the record, though, that would have supported that finding.
I don't think the judge quoted any statistics or anything.
Not only that, but I mean, there was literally no proof offered that would have supported that finding. I mean, is that true?
I don't think there's anything in the record that necessarily bolsters that finding.
Well, that's, so I think what Judge Greenholz is trying to get at, I mean, usually when you get a deterrence argument, it is the trial judge is going to make some sort of comment of, I've tried 15 theft cases in the past month, or, you know, we've had 100 different thefts. You can read the paper. I mean, they put it in context somehow, whether it's their own docket, whether it's cases they've seen coming out of other places, whether it's the news, whatever, or even some of them actually look at the AOC statistics. But
As they're required to do.
right. But just to say rape is happening too much. I'm not saying I disagree with that. One is too much. I get the point. But rape is happening too much in what context? I mean, in what are we deterring? And I understand your argument, one rape is too many, one murder is too many, I get that. But at the same time, it's not really what we're talking about when we're talking about there's a need for deterrent effect.
It certainly would have been better, Your Honors, if the judge had expounded and talked about statistics. I think the judge commented a little bit about her sort of personal knowledge, but even if this court sort of decides that factor wasn't really supported, again, we've got the lengthy history of criminal conduct which the judge talked about, and then the judge talked about how his risk was above average, how he had violated the sex offender registry, and I do want to comment on that. The defendant says he never did. Judge Greenholz, you're right. This offense itself is a violation, and to a greater point, the defendant admitted on cross-examination to multiple violations of the sex offender registry. The trial court is entitled to rely on that. It's on page 40 of the transcript.
Speaking of criminal conduct, criminal behavior, the defense made some statement that there was a bunch of arrests by this defendant that never went to trial or never were resolved. But that doesn't matter, does it? I mean, can we not consider arrest as criminal conduct or criminal behavior?
I think you certainly can, and the trial court certainly can. There's definitely some level of caution to make sure the police aren't just overcharging or anything.
But there has to be proof of the underlying facts, though, right?
There has to be some sort of proof of criminal conduct.
All right, and so what were the proof of the underlying facts?
I think the criminal conduct that the trial court considered were his convictions, his admitted violations of the sex offender registry, and his admitted involvement as a high-ranking member of a gang. And those are all in the record. Those are all established by either the pre-sentence report or the defendant's admissions. And so that's what the trial court was entitled to rely on.
So on the last factor, the defendant's admission to being a high-ranking member in a gang, what part of the sentencing statutes allows that consideration?
I think that can be considered as part of criminal conduct.
Membership in a gang?
As a high-ranking member of a gang that the court can take judicial notice of. I think that's acceptable.
Was there proof in the record that the gang was a criminal gang?
I don't think it was spelled out or it was fleshed out by the court. It was the Vice Lords gang, which I would argue that the court can take judicial notice.
Yeah, we're all familiar with the gang. We're all familiar with the gang, but I think maybe what I'm coming back to is maybe sort of along the lines of the deterrence aspect. What in the record supports the finding that membership in the gang is itself evidence of criminal behavior? Because there are members in a gang that don't commit crime. So where was the proof in the record that membership in the gang here was criminal behavior?
And I think that it wasn't fleshed out there, Your Honor. And again, but I think when you consider all of this criminal conduct, the trial court was entitled to consider it, and it was sufficient to establish the finding of both that he was a danger to the community, and then specifically with regards to these sex offender violations, in fact, the one that he committed with this offense also goes towards the fact that less restrictive means had been applied unsuccessfully.
So would you disagree then that with defense counsel that if we were to find that trial court abused its discretion, would you agree that there's enough here for us to do a de novo review?
I think so. If this court finds that the trial court didn't make adequate findings and did not, to quote Trent again, did not articulate the reasons for the sentence, then there's certainly more than enough evidence for this court to conduct a de novo review and find that confinement is appropriate. As I think both Your Honors have pointed out, again, this lengthy history of criminal conduct and these less restrictive means are blatantly obvious. And for that reason, we would ask that this court, affirm the trial court's findings. But if this court were to conduct a de novo review, it is clear that confinement is warranted. If there are no questions.
So the first Trent factor is amenability to rehabilitation. And what I hear the state arguing is that if we were to conduct a de novo review, there's little evidence of an amenability to rehabilitation because of the lengthy criminal history, because of the fact that he was on the sex offender registry, and that that less restrictive measure didn't prevent the crime that occurred here. Anything else?
I think there's also the high-risk assessment, the strong R report and the pre-sentence report that this court can rely on.
What was the, and you'll forgive me, I don't recall, in the psychosexual evaluation, what was the risk of reoffense?
I believe it was a high risk, Your Honor. I believe I put it in my brief. I don't remember specifically what it was, but I believe it was a maybe a moderate risk to reoffend and a high risk to reoffend in a sexual offense. But certainly whatever the record reflects would be more accurate. And so, you know, and when you're looking at the statutory factors for confinement, again, we submit, if this court conducts a de novo review, those factors weigh heavily in favor of confinement. If there are no further questions on the manner of service, I do want to briefly just turn to this confrontation clause issue. And I think your judges pointed out that this cross-examination had no real effect on the sentencing. The trial court didn't mention it when she considered the sentencing, but more importantly, there was no constitutional violation. The defendant in his brief seemed to concede that it was waived. I'm not sure whether he still says that or not, but it certainly was waived. In the trial court below, the defense counsel never argued that limiting cross-examination was a violation of my right to confront witnesses. So it's waived. And the defendant cannot establish all 5 plain error requirements. Most importantly, he cannot establish the breach of a clear and unequivocal rule of law. This court has repeatedly held that the confrontation clause does not apply as sentencing.
Well, I mean, it's a bit more refined than that, General. Right. I mean, you have the right to literally confront witnesses against you at the sentencing hearing, right? Which means that the state can't get up, present the witness, examine the witness, then sit down, and the court can say, no, you may not cross-examine. When we say Crawford doesn't apply, we're talking about the hearsay rules. And so we don't have to go through the Crawford analysis when we're talking about hearsay. Instead, we have a due process hearsay standard in sentencing. But to say that cross-examination, Crawford doesn't apply in sentencing, I mean, he's got a right to cross-examine the witnesses presented against him at the sentencing hearing.
Certainly he has a right to cross-examine. I think that's also procedural under the rules, but
I
limitation.
mean, we're not talking about a hearsay issue here. We're talking about just the fundamental ability to question the accuser, right?
That is the issue that that is being raised. My understanding of the case law, and if this court disagrees, it's still, I would submit it's not a breach of a clear and unequivocal rule of law. My understanding is that confrontation, if the state calls them under other procedural rules, they have the right to cross-examine, but I don't think that
It may be that I've misunderstood it. I thought when we say that Crawford doesn't apply, we're talking about hearsay issues and that we don't rely strictly upon the testimonial aspects of that, but instead we look to due process considerations and standards for admission of hearsay.
And that may be, Your Honor, and if I'm mistaken, then I'm sure this court will let me know. But then we can go to another plain error requirement, which is that consideration is not necessary to do substantial justice. Again, this court has sort of repeatedly pointed out that this witness's testimony, the victim's testimony, didn't go towards the manner of service that the defendant was required to impose. So to the extent that there was some error, it certainly does not rise to the level of plain error.
So the defense makes the argument that what the victim testified to, true or not, was a bunch of information about the defendant's gang affiliation and some other things, maybe even other criminal acts that he'd been involved in. If that's the case, did the trial court consider those things? And if so, shouldn't he be able to cross-examine on the credibility on those issues? Does come into play. It doesn't come into play on his guilt or innocence of the crime, but it comes into play on sentencing, does it not?
It could, if the trial court stated that she had considered it, but she didn't. She focused instead on the pre-sentence report, his psychosexual evaluation, and focused on his criminal conduct. And so we would submit that it does not apply.
Well, let me ask you one more. If we decide to review this de novo, how are we supposed to consider that testimony if it is testimony about, unchallenged testimony about criminal history?
I don't think this court needs to necessarily consider it. This court can, should it choose to, focus on the sort of crystal clear evidence that has absolutely no prejudice, that the defendant, excuse me, that the defendant simply isn't challenging. Again, his lengthy criminal history conduct, his pre-sentence report, the strong R evaluation, all of these things that he's not challenging are more than enough if this court were to conduct a de novo review. Unless this court has any further questions, we ask that you affirm the judgments of the trial court. Thank you.
Thank you, Mr. Coleman.
Thank you.
Mr. Working?
Thank you. We are not alleging judicial misconduct and an ethics violation by the trial court. We're not even saying on remand the outcome might be a lot different, but what we've argued is that the hearing was not conducted correctly and should be sent back to be conducted correctly.
Well, Mr. Working, I think at least I've looked at this part of it. I did look at the record there, and we would agree with you, I think, probably, that this sentencing hearing was not handled in the way we would like to have seen it handled, and that's often the case. But again, if we think that, we have two choices. We could either remand it to the trial court and try to tell the trial court to do it this way, or we could have a de novo hearing and rule ourselves and explain the errors that the trial court made, or the manner in which the trial court conducted the hearing, or the way it should have been conducted. But again, it's been asked, why is there not enough evidence in this record for a de novo hearing?
Well, almost all of the evidence that's in the record is improper evidence, is one of the main reasons. And if I may, the defendant's prior record, I think he has a couple of misdemeanors. Perhaps that's enough for this court to decide, but there is a felony charge that he had. He was arrested on a felony. He proceeds to trial, and according to this transcript, the state was unable to proceed at the jury trial that day, reduced his charge to a D felony.
I mean, that's the attempt aggravated sexual battery?
Yes, sir, and
All right,
that is
so
what puts
we've
him
got-
on the register.
We've got attempt aggravated sexual battery, we have theft ×2, we have aggravated burglary, and we have unlawful possession of a weapon.
And almost all of them are pled at the same time. I think there's a misdemeanor that's pled separately.
All right, and this is the child rape case?
That was the arrest. Yes.
Okay, all right.
That was the arrest.
And so
of course,
how is all of that improper?
well, he wasn't convicted of child rape, and the judge says, I'm sentencing you because you're convicted because of your child rape charge. And she says, you violated this sex offender registry many, many, many times. In fact, and what the state just alluded to here at the podium, he does not admit to many violations. What the prosecutor does is go through a series of his arrests and say, do you remember that? Do you remember that? Do you remember that? He's not admitting to, I remember being arrested. Those were the questions were. And in fact, the prosecutor even says, yeah, I just missed a couple of those on you.
Well, I mean, all of this is indicated in the pre-sentence investigation report, and there was not an objection to the pre-sentence investigation report, and so either the trial court or this court then can take notice of the criminal history under those circumstances.
I think that this court can take proper notice of his convictions according to our law, yes, and we're distinct from the federal system in that the federal system does consider other relevant conduct besides convictions, but our law is not that.
I mean, we can consider criminal behavior when it's effectively proven, but you started off the argument by saying that there was improper evidence of criminal convictions. The pre-sentence report, I think, belies that argument, though.
Well, what the judge says, okay, is, what the judge says in the ruling is she cites an A felony he's not convicted of, violations of the sex offender registry he's not convicted of, and she says, we don't know what he's done, really. He may have been arrested, but whatever, I'm sentencing him. He may not have been arrested.
But what the judge said is not what we're talking about. We're talking about what in the record precludes us from conducting a de novo review. I mean, if there is a pre-sentence report in the record, I don't care what the judge said about it because I'm conducting a de novo review. So
Okay.
if there's a pre-sentence report and a psychosexual evaluation and a strong R assessment report in the record.
There was a dispute in this case at the sentencing hearing, and the lawyers who conducted it, which was not I, about how this offense was committed. It was not alleged to be an act by force, but by intoxication. The
Okay,
defense was not allowed to cross-examine the victim about that at all.
But the defendant pled guilty to a set of facts.
I agree
Those are
with
the
that.
facts we consider.
I agree
So,
with
so we've got a guilty plea transcript that is the facts of the case. Whether the defendant now wants to dispute those facts is different. I've got a pre-sentence report, I've got a psychosexual evaluation, and I've got a strong R assessment. How is any of that, quote, as you said, improper evidence, and that we can't consider in conducting a de novo review?
My argument was not that this court can't consider it. My argument was that this court should remand, my argument was that the court specifically cites to considering many things that were not proper.
Right, but the question to you was, if we conducted a novo review, why is the record not sufficient?
Well, I think the record may go to perhaps 2 or 3 of the 8 factors, and it should be further developed in the lower court. My time is up, and thank you very much.
Thank
All
you.
right, thank you. You need a break before we do this last one?
I don't know, do you need one on that?
I'm all right, although I did forget my iPad.
Just take 5 minutes and go get it.
We're going to take just a real short break.
All right.